If your family member got an order of deportation, you may be thinking that there's nothing else you could do, everything's over. But what I'm about to share with you could actually be the difference between your family being torn apart forever or staying together in the United States. I'm Jayson DiMaria, the DiMaria Law Firm, and I've been fighting for the past 20 years to keep families together. There are legal options that most people don't even know about, but you have to act fast because time is not on your side. When someone gets a deportation order, most families think the fight is over. They think their loved one has to leave the country and there's nothing they could do about it. But that's exactly what the government wants you to think. Here's the truth. A deportation order is not the end of the road. It's actually just the beginning of a different kind of fight. But you need to understand what you're dealing with and you need to actually act immediately. There are 3 different types of deportation orders, and each one has different options for fighting back. The first one is called an in absentia order. That's when someone was ordered deported because they didn't show up to court. The second is when someone appeared in court, but they lost their case. The third is when someone signed papers agreeing to be deported. But here's what most people don't realize. Even after a deportation order is issued, there's still a legal way to fight it. The problem is most families don't know these options exist, and by the time they find out, it's too late. The most powerful tool for fighting an in absentia deportation order is proving that you never received proper notice of your court hearing. Most people don't realize that the court is required to send notices to your most recent address, and if they send it to the wrong address, the entire order can be invalid. This is exactly what happened to my client Carlos. His family thought his case was hopeless. He had been ordered deported 3 years earlier after missing his court hearing. His family had given up hope. They were planning for him to leave the country, but when Carlos came to my office, I discovered something his previous lawyer had missed. Carlos had never received proper notice of his court hearing because he had moved and the court had the wrong address. We were able to file a motion to reopen his case, and today Carlos has his green card. But Carlos was lucky because he came to the office before it was too late. Because there are strict deadlines for fighting deportation orders, and if you miss them, your options become much more limited. The most important thing you need to understand is that time is your enemy. For most types of relief after a deportation order, you have very limited time to act. See, if your family member was ordered deported because they missed court, you typically have only 180 days from the date of the order to file a motion to reopen. Miss that deadline, and your options become much more difficult. If your family member appeared in court and lost, you have only 30 days to file an appeal to the Board of Immigration Appeals. After that, you might still have options, but they're much harder to win. Even if the normal deadlines have passed, there's still one powerful tool can reopen a deportation case. It's a motion to reopen based on changed circumstances or new evidence. This is more complicated though than the standard motion to reopen, but it can be incredibly powerful. Here's how it works. If there's been significant changes in the law, in the country conditions that you lived in, or if new evidence has come to light that wasn't available during the original case, you might be able to reopen the case even years later. The key to winning a changed circumstances case is documenting how the conditions in your home country have deteriorated since your original hearing, making return dangerous or even impossible. For example, I had a client who was ordered deported in 2018. The conditions in his home country have deteriorated significantly since then. There's now widespread violence and persecution of people like him. We were able to reopen his case based on these changed country conditions, and we won his case. But changed country conditions isn't the only way to reopen the original case. There are other types of new evidence that can be even more powerful. One of the most overlooked opportunities is when someone becomes eligible for relief that they weren't eligible for at the time of their original case. This could be through being a crime victim, domestic violence survivor, or changes in family circumstances. Every situation is different. We would have to take a look at those exact circumstances, but maybe your family member is now eligible for relief that they weren't eligible for before. Maybe they've been a victim of a crime and can now apply for a U visa. Maybe they've been a victim of domestic violence and could apply for VAWA protection. I recently reopened a case for a woman who had been deported 5 years ago. Ever since her deportation order, she had been the victim of a serious crime and was now eligible for a U visa. We were able to reopen her case, and she's now on a path to getting her green card. But here's something that might surprise you. Sometimes the best strategy isn't to reopen the case at all. Sometimes there's a completely different path that can protect your family member from deportation. Even if you can't reopen the deportation case, your family member might be eligible for other forms of protection. They might qualify for protection under the Convention Against Torture if they would face torture in their home country. They might be eligible for withholding of removal if they would face persecution. These forms of relief don't erase the deportation order, but they can prevent your family member from actually being deported. It's not perfect, they won't get a green card, but they can stay in the United States with their family. But there's one strategy that's often overlooked, and it might be the most powerful option at all. It involves using family relationships in a way that most people don't even understand. If your family member has been ordered deported, don't give up hope. Call my office right now, 973-934-5854. We offer same-day consultations, and I guarantee you we'll discuss your case today. Time is critical. You have to call now. If your family member has been ordered deported, but they have a qualifying family relationship, there might be a way to get them legal status through a completely new case, even with the deportation order in place. The key to overcoming a deportation order through family petitions is understanding that certain family relationships can forgive previous immigration violations, including deportation orders, through what's called a waiver process. Here's how this works. If your family member is married to a U.S. citizen, or if they have U.S. citizen children over the age of 21, they might be able to apply for a waiver of the deportation order and get their green card through their family relationship. This is called a waiver of inadmissibility, and it's specifically designed for people who have deportation orders but have strong family ties to the United States. I had a client who had been ordered deported 10 years earlier. He had been living in fear, hiding from ICE, but his U.S. citizen son turned 21, and we were able to file a petition for him with a waiver. Today he has a green card and he doesn't have to hide anymore. But family petitions aren't the only way to overcome a deportation order. There's another option that many people qualify for, but they don't know about. Cancellation of removal after a deportation order requires proving that your removal would cause exceptional and extremely unusual hardship to a qualifying family member. It's a higher standard than your regular hardship, but it is achievable with the right evidence. You may still be eligible for this even after your in absentia removal order gets reopened. If your family member has been in the United States for a long time and you could show their deportation would cause exceptional hardship to their U.S. citizen or permanent resident family members, they might be eligible for cancellation and removal even after being ordered deported if that original notice to appear was not filed with the court correctly. Super important to have an attorney take a look at that, because if that original form was not done correctly, they can have an opportunity to file for this cancellation and removal. The key is showing the exceptional hardship. It's not just emotional hardship, it has to be exceptional. Medical conditions, financial hardship, country conditions, all of these will be looked at by the court to determine whether or not there's exceptional hardship. But here's the most important thing I could tell you. None of these options work if you wait too long. Every day you delay, your family member is at risk of being arrested and deported. ICE is actively looking for people with deportation orders. They have your family member's information. They know where they live. They know where they work. Every day that passes is another day that ICE could show up at your door. But here's what you could do right now to protect them. First, make sure they know their rights if ICE comes to their home. They don't have to open the door without a warrant. They have a right to remain silent. Second, have a plan, know who to call if they get arrested. Have important documents ready. Have our phone number programmed in their phone, 973-934-5854. Third, explore your legal options immediately. Don't wait to see if ICE will find them. Be proactive. The immigration system is designed to make you give up hope. It's designed to make you think that a deportation order is the end of the story. But I've been doing this for 20 years, and I've seen families reunited even after deportation orders. I've seen people get green cards even after being ordered deported. But I've also seen families wait too long. I've seen people give up when they still had options. Don't let that be your family. Now that you know what to do, even if a judge ordered you deported, there's a major legal development that just happened with Trump's massive deportation plan that could completely change what ICE can and can't do, and what ICE has been doing behind the scenes. Most people have no idea how this affects them or their families. So check out this video where I break down exactly what this court ruling means for you and your family's safety, because understanding these changes could be the difference between staying protected and being caught off guard when ICE comes to your neighborhood.